reject this interpretation and consider that Israel is fully obligated to recognize the applicability of Convention 4 to the disputed territories. Well, since I worked for 16 years for the ICRC, 10 of those in its legal division, I must disclose that I disagree with my former employer. Big time. What I would like to examine now here is whether the ICRC, for the most part in unison with the majority of the international community, has been applying these principles in a uniform fashion. If they did, then we do need to pay attention to their stringent interpretation of the applicability of the Fourth Geneva Convention. If they did not, then we are entitled to ask whether we are looking at a case of double standard, and if so, why it exists in the first place. Let's start with Tibet. In 1950, China invaded Tibet, declaring it one of its provinces and brutally conquered it before annexing it. In the last 62 years that has been there ever since, have the ICRC and the world done or said anything about this? No. Do they send regular press releases protesting the mistreatment of the Tibetan population by the Chinese occupiers? No. Do they protest the illegal occupation of Tibet based on the Fourth Geneva Convention? No. Did they protest the forcible transfer of hundreds of thousands of ethnic Chinese into Tibet? No. The reason is obvious. No one wants to criticize, let alone confront, China. Next, we need to turn our gaze towards the Western Sahara. This former Spanish colony under Morocco, located under Morocco on the Atlantic coast, was illegally appropriated by Morocco in 1975 when the Spaniards left the place without leaving behind them an indigenous government. The same questions as above in the case of Tibet apply, with the same answers, except for the fact that the annexation started peacefully but degenerated quickly into a guerrilla war that is still ongoing today. So the question again is, does anybody care about Western Sahara being illegally occupied by Morocco? No. The answer is obvious. Did the ICRC protest this blatant and illegal land grab? No. Is it clamoring that Morocco is violating the Fourth Geneva Convention? No. And finally, let's consider the case of Cyprus. For the sake of brevity, I will skip to the circumstances that led Turkey to invade and brutally occupy the northern half of Cyprus in 1974, removing in the process all the Greek population from that area and bringing in Turkish settlers to replace them. To this day, the Turks are still illegally occupying the northern half of the island. And the question is, while the ICRC was involved in helping the victims of that conflict, it has not condemned Turkey for not applying the Fourth Geneva Convention or for violating its rules. So the lesson to be drawn from all these three cases are clear. There is a double standard at play. The reason is relatively easy to understand. Realpolitik, the original German word is Realpolitik. The ICRC, like most of the world, is very vocal when it criticizes Israel, or the US for that matter, because it knows fully well that it has no reason to fear retribution of any sort from these two countries. The same cannot be said of China, Turkey, Morocco, countries who have shown to have singularly thin skins and bristle at the slightest hint of criticism regarding their respective illegal occupations and appropriation of territories that do not belong to them. This fundamental inequity must be kept in mind when one considers the way the world as a whole, with the open support of institutions like the ICRC, treats Israel. A clear double standard emerges. Israel is expected to respect all the rules of international law and is harshly criticized for the slightest perceived offense, not to mention situations where offenses are created out of thin air like the Goldstone report. But on the other side of the equation, murderous regimes that have killed scores of their own citizens or others through terrorism do not even receive a slap on the wrist. Why? Again, a not-so-courageous world, including a not-so-courageous ICRC, only dare criticize countries or groups that they don't have anything to fear from in harsh and sometimes lethal retaliation. I'm almost done. I know, I promise. Ooh, I'm over time. Okay. There is no shortage of voices claiming that this is not a double standard, but that it simply reflects the heightened sophistication of Israeli society as opposed to the impoverished condition of the Palestinian people, hampered as they are by the, quote, occupation, quote, of their land, quote, unquote. Therefore, Israel is deemed more responsible than the Palestinians are. What that line of thought really means is that the Palestinians have not reached the capability of functioning as a sovereign and responsible nation. Is it a valid excuse? I think not. When a new nation appears on the world scene, they not only acquire rights, they also acquire duties. The Palestinians are no exception. More broadly, we are now witnessing a disturbing tendency to use international law at the behest of the Palestinians as a tool to attack Israel exclusively. Witness the pathological obsession against Israel that pervades the United Nations and dominates its Human Rights Council. Witness the rash of lawfare cases where the otherwise valid concept of universal jurisdiction is abused to launch unwarranted lawsuits against Israeli officials under phony accusations of war crimes. Witness the amazingly biased judgment rendered by the International Court of Justice against what it persisted to call the Israeli security wall, blithely ignoring the reason for the security fence's existence in the first place: Palestinian terrorism, the most egregious violation of international humanitarian law. This trend is worrisome and needs to be addressed, lest the world community ends up in a not-so-distant future with two different categories of countries: the ones that honor and pay attention to their international legal obligations, and the ones that do not. The ones that submit their behavior to the constraints of international law, and the ones who ignore these constraints. Soon a choice will have to be made. Either the same rules apply to all, or they do not apply to anyone. There cannot be two regiments coexisting at the same time. To advocate such a formula is to call for chaos in the international arena. To conclude, what is the solution? The short answer is that we demand, forcefully if need be, that all countries abide in the same way to the same rules, in particular human rights and humanitarian law rules. Thank you very much.
Well, it is an honor to be on the same panel as Avi Bell and J.J. Surbeck. I asked Avi for permission, and he kindly gave it, for me to reprint at Jewish Current Issues the opening statement he made in the debate with Justice Goldstone, and I did so not only because it is a devastating critique, as devastating as the one he made this evening, but also I think a historic document, and I commend it to all of you. J.J. Surbeck's reputation as one of the premier experts in international law precedes him, and then there's me. I'm going to speak about the coming crisis in September, which refers to the fact that in September the Palestinians will request recognition of a Palestinian state with borders on the pre-June 1967 lines, which are really the 1949 armistice lines in the first Arab war against Israel, on land that is legitimately occupied by Israel as a result of a defensive war in 1967, and whose final status under multiple UN resolutions, international agreements, and formal U.S. letters issued by successive U.S. administrations of both political parties to Israel is supposed to be the subject only of direct negotiation between the parties and not resolved by the unilateral action of either of them or by a UN diktat. So you can look at this coming car crash in September through three different prisms. First, through the prism of the moribund peace process, which for quite a while has been a non-peace, non-process. Second, through the prism of U.S.-Israeli relations, which seem to alternate between the administration's Chicago-style diplomacy in odd-numbered years and charm offensives in even-numbered years. And you can look at it, third, through the prism, the broader prism of the role of the United States and its reputation in international affairs. I'm going to look briefly at all three prisms, and I'm going to conclude that the dangers of the coming UN resolution are far greater for the United States than they are for Israel. That there will be a test for Israel, but it is going to come not in September, but in May, that is to say next month. And it will be a different sort of test than the one that people currently think is coming. So to start with the effect of the UN resolution on the peace process, recall that 8 years ago, both Israel and the Palestinian Authority formally adopted the roadmap of the quartet comprised of the United States, Russia, the UN, and the EU. The quartet always reminds me of the answer to one of Karnak the Magnificent's questions: name a superpower, a former superpower, and two organizations with no power. What happens in the quartet is what the U.S. wants to happen. The quartet cannot even meet if the U.S. does not want it to meet. So if the roadmap fails, it will be a massive U.S. failure in a peace process that the U.S. has invested nearly 8 years, and really 2 decades if you start with Oslo, in an effort to culminate in a Palestinian state in a legal fashion, meeting the principles of international law that both Avi and JJ discussed. So as you all know, the roadmap called for 3 phases. First, a sustained effort to dismantle Hamas and other terrorist organizations. Second, a Palestinian state with provisional powers and provisional territory. And third, final status negotiations on the issues of borders, Jerusalem, refugees, and security. But no effort was ever made to dismantle Hamas. And after the Palestinian legislative election of 2006 and the Hamas coup in 2007, compliance with Phase 1 became impossible. The Palestinians also categorically rejected Phase 2, and the U.S. never insisted that they abide by it. Instead, in the last year of the Bush administration, the roadmap was accelerated, to use Secretary Rice's term, to skip Phase 1 and skip Phase 2, and a year-long Phase 3 final status negotiation ended when the Palestinians rejected the Israeli offer of a state on 100% of the West Bank after line